And see that Mr. DiCarlo is hooked up, but I don't see him yet. Mr. DiCarlo, can you hear us? There you are. Okay.
There we go.
You disappeared again. There you are.
Thank you, Your Honor. Appreciate your patience.
Hey, you know what? You should have seen Judge Black earlier on today. So. We couldn't hear him. I kind of like him like that. I'm teasing, just teasing. All right. Mr. Reese, you're up first.
Good morning, and may it please the court. My name is Ryan Reese. I'm with the law firm of Moore, Bowman, and Reese. I represent the plaintiff appellant Lake Lincoln in this matter. I'd like to reserve 5 minutes for rebuttal, please. This is a constitutional takings case governed by the per se rule announced by the United States Supreme Court in 1992 Lucas decision. That is, when the owner is called upon to sacrifice all economically beneficial uses of his land in the name of the common good, he has suffered a taking. The lone issue in this appeal is a predicate to that takings question. That is, what is the quote relevant parcel or unit of property upon which the government's regulatory deprivation is to be measured. Our position is that the relevant parcel is the 10-acre property owned by Lake Lincoln and pled in the complaint. The county has argued, and the trial court ultimately determined, that the relevant parcel was the entire 1,100 plus acre Terra community, which had been constructed over multiple phases and with varying land uses over the last 40 years. And so under that overbroad predicate, obviously we could not prove a taking. And so a final summary judgment was entered for the county, and this is a direct appeal from that final judgment. It's our position that the trial court misapplied the three-factor JIRC test to determine what the relevant parcel was. Rather than taking our takings claim as pled, which was the 10-acre parcel, as the relevant parcel, the trial court found dispositive the property's location within and governance by the state DRI, or Development of Regional Impact Framework. We contend that legal ruling was in error. The proper application of these undisputed facts to the JIRC test demonstrates that the 10-acre subject property is the relevant parcel for purposes of the plaintiff's takings claim. And so measuring the county's deprivation of use against that 10-acre property, it's undeniable. Yes, sir.
Just to make sure I understand this correctly, that 10-acre parcel, there was a period of about a decade where there was no ability to use that property for anything, for any gain or development, but then that ultimately changed and they were given the right to use the property for residential use. Is that right? Residential construction?
That's correct, Your Honor. And so
what changed the course of things as far as you can tell?
Well, that's quite honestly a better question for the county. The rezoning of this property was initiated at the request of the Manatee County Board of County Commissioners, and that was the rezoning to the limited residential uses. That was not an endeavor undertaken by the applicant. It was a very same use that had been agreed to as part of the original development application back in 2010, which was recommended by staff and ultimately denied by the Board of County Commissioners in 2010. So quite frankly, how do you account for the Board of County Commissioners about face on the property's available land uses? That's a question that's never really been answered, and probably a better question directed to Mr. DiCarlo. But to Your Honors,
somebody may have
Rich Northcutt, you're muted.
Go ahead. Let me ask you this. So I've got.
Yeah, go ahead.
Let me ask. Go ahead. I'm sorry. Steve.
Oh, I was just going to say, but why the change happened was not relevant to the decision below, right? Because your site changed its claim to temporary taking, or is that correct?
That's correct, Your Honor. This case initially, because the county unequivocally stated that no uses would be allowed on the property, originated as a permanent takings case.
Right.
And
And
of course,
they rezoned or they changed to allow residential, you changed your claim to a temporary.
we did indeed, and that's supported by the United States Supreme Court First English case.
So what I'm saying is the reason for the change isn't really relevant to our decision making today, correct?
That's correct. And it's unequivocal that from that 9-year period between 2010, October of 2010 to September of 2019, the subject property could appreciate no land use. So.
All right. I'm sorry, Judge Jacobus, you got a question?
Let me ask you this. If the what would happen, would we be where we are today if the property had never changed title? In other words, if the original developer of the Terra DRA remained the same throughout, and here we are today, would the relevant parcel be the whole, 1,000 acres, or would it still be the 10.32?
To answer Your Honor's question, it would make absolutely no difference at all, so long as the Terra entity did not own any property physically contiguous to the subject parcel. And that's
at this time, is what you're saying. Or
That's-
at the time of the taking, is what you're saying.
That's correct. That's correct. There's a huge temporal component here, and that's where the parties disagree. The county wants to retroactively go back and look at essentially the common title that was drained to the 1,200 acres and use that acreage against Lake Lincoln, who owns, I think at the time of the claim, only owned 12 acres of property within the entire, 1,100 acre development. I think that's 1/10 of 1% of the overall land acreage.
Well, let me then get and you raise a good point in terms of the temporal aspect of this, I think. Do you agree or disagree that the fact that it's a separate legal entity is not the end of the analysis that common ownership, common management can be considered?
It can be considered. You've seen that in the.
Let's just stop right there, though. So the temporal, that's where the temporal aspect of this comes in, correct? So if this separation out of the legal entity or the legal ownership happened many years ago, that might be weighed versus more recently.
Absolutely. Absolutely.
The idea would be theoretically, from the government's perspective, is to avoid a manipulation just by, transferring to creating a new entity and transferring to that and now having a claim.
That's correct, Your Honor, but I would caveat with the fact that you also have to have physical contiguity and use.
I get that, but
let's say, for instance, Lake Lincoln or its predecessor, which was Higgs Lake, and then I think formerly Terra Manatee. Let's say they owned 100 acres dispersed throughout the 1,200 acre DRI. That property and those lands still aren't physically contiguous.
right.
And it's also incredibly significant. And the case law says the most controlling factor is unity of use. And so you've got to have all three there. So I want to start with the things that both parties agree on.
If I can, just real quick on the ownership issue. If the entity that owned it at the time of the taking was totally unrelated to anybody of the original development, we wouldn't be here today, right? The relevant parcel would be the 10.3 acres, correct?
That's absolutely correct. And I would take that one step further. If we were not governed by the state's DRI regulatory scheme, we wouldn't be here today. And you see, I mean, the county's argued in its briefing and the trial court determined every aspect or every finding that the trial court reached was relevant to the fact that this is located within a DRI. I mean,
But Mr. Reese, isn't it fair to say that DRIs typically are voluntary on the part of the developers, that they go to the state and they want to create a development of regional impact, and therefore this ordinance is created and so forth? I mean, there is a regulatory scheme, but this isn't like the state came along to your client sometime years ago and said, hey, you have to be a DRI.
I think it's absolutely a state mandated scheme. I mean, no developer goes in and
But it's one that the developer can use and take advantage of. It has its benefits to the developer too, correct?
it does. There's flexibility in shifting the pieces around residential, commercial over time based on.
Right. So it's not, it is a, you know, a land development tool, growth management tool for the state, but it's also a development tool for the developer.
That's correct. That's correct. But the trial court elevated to essentially dispositive status the fact that this property was located within a DRI and shares the common pool of entitlements. It didn't make any finding at the trial court level that had anything to do other than the DRI. I mean, it's very clear in the opinion, and that elevated it to essentially dispositive status. So we would contend that really the first two factors should end the inquiry here: ownership and contiguity under the Jurek test. The trial court recognized inherently that Lake Lincoln did not own any other property adjacent to the 10.32 acre subject property. And as I said previously, as the date of the alleged taking, the community was nearly built out and it only owned, 1/10 of 1% of the entire acreage. The other, 1,100 acres were all owned and continue to be owned by private parties entirely unaffiliated with Lake Lincoln altogether. And so under Jurek, we would contend that the ownership and contiguity issue should conclude the analysis altogether. Only if you find ownership and contiguity do you then go to unity of use. And of course, the court would apply the 9 sub-factors stated in the 3rd District's Jurek opinion and affirmed by the Florida Supreme Court on appeal. Legal divisions, intent of the owner, dependence between parcels, highest and best use, etc. And here it's clear that each of those 9 sub-factors supported Lake Lincoln or weighed in favor of Lake Lincoln. And I've set forth some of that analysis in the initial brief at pages 24 through 29 and in the reply brief at pages 11 through 17. It's also clear in our trial court motion for summary judgment. And respectfully, it's not a close call. I mean,
Mr. Reese, you're at 5 minutes left, so we've helped you use your time. Use them as you please.
Sure. And that's my 5 minutes of rebuttal, Your Honor. Okay. I'll just briefly make one quick point. The trial court didn't go through any of the use sub-factors. Instead, it just made broad generalizations about the property's governance by the DRI regulatory scheme. And that's improper. It's the use of the subject parcel that matters, not use of all the lands that were originally purchased and developed over the 40-year history. And that's where we get into some of the case law. And I'll save my remaining time to discuss that in rebuttal.
Okay. Great. You got right a little over 4 minutes. Okay, Mr. DiCarlo.
Hey, please, the court. Assistant County Attorney Chris DiCarlo. I'm here together with my co-counsel Whitney Hodges on behalf of the appellee Manatee County. Despite what the court just heard, this case is not just about the 10-acre piece of property. It's about a 1,124-acre development of regional impact called the Terra DRI. And it's about the appellant's 10-acre piece of property in the larger context of its place as part of that DRI. This is a DRI which, as the court can tell from the abundant appellate record, has been commonly treated and commonly used by the appellant and its predecessor as a single economic unit. And that factor is critically important for the court to keep in mind in looking at the issues in this case for the past 40 years. Now, it's the county's position that the circuit court wisely rejected what I would characterize as the appellant's artificial attempt to sever the 10-acre parcel from the DRI for the purpose of yes, Your Honor.
If this property was owned by an entity untotally related to the original DRI developers or any of their successors, would the relevant parcel be the 10.32 acres?
I'm sorry, Your Honor. I couldn't hear the first part of your question, sir.
I think, and Judge Jacobus can correct me if I'm wrong. I think what he said is if this parcel was owned by an entity that was totally unrelated to any of the entities that have been involved in the DRI before, would that make a difference? Is that correct, Judge Jacobus? Is that what you're asking?
That's it. Yes.
Your Honor, Judge Jacobus, I think that's probably a very accurate assertion. I think if we were dealing with a entity that was not affiliated with Terra from the get-go, in other words, we're dealing with what was essentially the same developer throughout the entire 40-year development history. If we were dealing with a developer that was a totally separate entity or a totally separate company, I think we might be having a different conversation, in the interest of intellectual honesty.
You hear me? You look at some other case, one I'm familiar with is Lost Tree Village, which is John's Island over where I live. The Lost Tree Village is one of the cases where the Corps of Engineers, in other words, it was a huge development, a DRI, and they had a small parcel of land that was a wetland they could use, and the Corps said they couldn't, and the trial court basically said, look, even though you're the original developer, they made the relevant parcel the parcel that the Corps said they couldn't build on. In other words, they kind of took a different approach. They said it was a long-term development. They sold different parts of it. Some was commercial, some were, condos, some were single family. It's just like this DRI. I mean, it seems like factually it's somewhat the same. It's Lost Tree Village versus the Corps of Engineers. But why is that different? Why isn't that like this case? I mean, when along the way, they could have used this parcel up until sometime the county changed the zoning on it. But
Well, Judge, I would respectfully suggest to the court that Lost Tree is completely factually distinguishable. In that particular case, one of the important distinguishing features that is not present in this case is the fact that the property owner in Lost Tree Village did not treat the particular parcel at issue, which was called Plat 57, and the
Right.
St. John Islands community as part of the same economic unit. And there's quite a bit of evidence in the record about that. That case is distinguishable from our situation because here, both Lake Lincoln and its predecessor, Terra Manatee Inc., have treated the entire DRI as a single economic unit. And the whole DRI was always the relevant parcel in this case because all of the requirements for development in this particular case are subject to the DRI development order and the accompanying zoning ordinance, which have been in place since 1980. Lost Tree was not a case dealing with that similar type of regulatory scheme, such as what we have here, Your Honor.
But that's true regardless of who owns part of the 10.32 acres, correct? In other words, if it's an unrelated owner, they're still subject to the DRI, restrictions and regulations and zoning and all that.
That's correct, Judge, but that's exactly part of my point with regard to this case, is that regardless of who is owning this particular piece of property, because of the fact that we are under the confines of a DRI, all property in the DRI is subject to the regulations which govern the development order and the zoning ordinance. So when Mr. Higgs originally established this DRI, and I do think that, Your Honor, to your point earlier, Judge Northcutt, your question I think was very salient and very appropriate. The fact of the matter is that DRIs are something that developers come in for because it gives them the opportunity to entitle very large tracts of property. And those entitlements that they receive, Your Honor, are extremely lucrative and extremely valuable.
There's a societal trade-off. The government gets to do some growth management and the developer gets some certainty about entitlement to the property.
That's exactly correct, Your Honor. And the fact of the matter is that the case that the appellant is trying to frame for the court is one where they are trying to frame this case in terms of solely that 10 acres. But all of the record is clear, and Judge Sniffen did an excellent job of very carefully and meticulously analyzing the record. The record is very clear, and I would point to the court, probably one of the most damning things in the record for the appellant's position is the appellant's own development application with regard to this piece of property. I mean, I repeated this quite a bit in my brief, but I think it's very important when the court's thinking about these issues, the court has to keep in mind that the issues are framed by virtue of the fact that what the appellant came in for was an amendment to a DRI development order and a zoning ordinance governing the entire Terra DRI. They did not come in with a development application seeking to rezone and entitle only the 10-acre piece of property. Their development application came in, and this 10-acre piece of property, frankly, was a very small portion of what it was that they were asking the board to evaluate. And so when the board rendered its decision, the board was not rendering a decision on a development application only for a 10-acre piece of property. It was rendering a development decision as it relates to the entire 1,100-acre DRI. And now what the appellant has come in and said is, well, we didn't get the one thing that we wanted out of that development application, because the court should keep in mind that every other component of that development application that Lake Lincoln applied for was approved by the board. There was one aspect of that development application that the board found was not consistent with the comprehensive plan, and that was the rezone of this property to planned development commercial and entitling that property. Now, that didn't mean that the property owner lost any of its development rights. To go to your point, Judge Northcutt, about this bank of entitlements that they received with regard to the DRI as a whole, they still retained all of those development entitlements. In fact, they even could have come back and they could have applied for some other type of use on this property, but they elected not to do that. Instead, what they elected to do was they elected to file a takings claim. And what they're trying to argue to the court is they're trying to argue a per se taking, and they're trying to narrow the relevant parcel in this case to the 10 acres. And the reason for that tactic is very simple. Unless they can convince the court that the relevant parcel is the 10 acres, then they do not have a takings claim. And the case law is very clear that the analysis that the court has to go through is not linked to any one particular issue. It's a multi-factored analysis. We talk about things like physical contiguity. We talk about things like unity of ownership. We talk about things like unity of use. I would respectfully suggest to the court that appellant's counsel's characterization of Judge Sniffin's order is completely inaccurate. Judge Sniffin did an excellent job of carefully analyzing the development history of this case. It's a 40-year development history. This is not something that just happened over the span of a short period of time. Over 40 years, this developer came in and they applied for these development rights. And then every time they came in to apply for an amendment to the development order and the zoning ordinance, they were applying for an amendment to two ordinances which controlled the DRI as a whole. That's why when their longtime land use lawyer, Patricia Petroff, and their longtime land use planner, Robert Lombardo, came in and filed this development application with the county, they weren't coming in to ask for a rezone as it relates to 10 acres. They were coming in and asking for this rezone in the context of the overall DRI development. And it was part of several things that they asked for. And they had to do that because the entire DRI is governed by the development order and the zoning ordinance. And when they want to come in and make changes to it, they have to necessarily change both the development order and the zoning ordinance. I mean, really to sort of summarize this.
Let me ask you, wouldn't that be true again if the owner of the property at this time was totally unrelated to the developer? They would have to do the same thing, wouldn't they?
Well, Judge, if any owner is going to come in and is going to request some type of development entitlement that is different than what has already been entitled under the DRI as a whole, they would have to do that. The reality
that a subsequent purchaser, unrelated purchaser, would be buying the property subject to and with the development rights that came with it, but subject to the DRI as it existed, correct?
That is exactly correct, Your Honor. And in practical point of fact, what typically happens is that when an agreement is made between a subsequent purchaser to come in, there's typically an agreement with the owner of the property that they're going to join in any development applications as it relates to that subsequent purchaser, because those development rights have to come from the bank of entitlements that govern the DRI as a whole.
So that's what would happen like in a planned community where a developer comes in and buys a subset of the thing in order to build houses to sell. They're buying it with these rights attached, no more, no less.
That's absolutely correct, Judge. And that's part of the reason why this applicant had to come in with a development application, because they didn't have any development entitlements that were ever assigned to this particular piece of property over the course of its 40-year history. If they had development entitlements that were assigned to the parcel over the 40-year history, they wouldn't have had to come in front of the board and ask for the property to be entitled. Typically, they can do those things administratively. So what I'm concerned about, what I want to bring the court's focus back to is that the case that the appellant is trying to argue to the court, the case that they want the court to evaluate, is a per se taking claim. That's not the case that they have. What they have is a case where they themselves treated this parcel as a whole economic unit, and they didn't do it for a little bit of time. They did it over the course of 40 years. The circuit court looked at the realities, the economic realities of the situation. It evaluated where the parcel is. The parcel has always been, Your Honor, and to this day remains part of the DRI. That is completely undisputed. So it is still within the boundaries of the Terra DRI. They have never severed it from the DRI. They have never moved to dissolve the Terra DRI development order. Judge Jacobus, to your point, if they had made efforts to do those types of things, then I think we'd be talking about a different situation where they're coming in for a standalone development application only for the 10-acre parcel. But they didn't do that. They left it as part of the DRI. And in fact, Your Honor, they also, when they came in for their development application, they were seeking to transfer development entitlements from the overall bank of DRI entitlements onto the property. So really what they're doing is, on the one hand, they're saying to the court, Your Honors, disregard the 40-year development history and how we treated this property for 40 years. Disregard the fact that we came in and we asked for a development application that sought changes to 2 ordinances that govern the DRI as a whole. Disregard the fact that we asked for development entitlements from within the DRI to be transferred onto this particular piece of property so we can entitle it for development. And just think about this piece of property as a standalone piece of property. And what I would respectfully suggest to the court is that the circuit court got it right.
Just by way of background, you mentioned something a minute ago that gave me thought, and you can probably tell from my questions, I was not a land use attorney. So I educate myself somewhat every time I have one of these cases. So you mentioned, okay, if they had sought to do this parcel, rezone this parcel, et cetera, separately outside of the DRI, the advantage to keeping it within as part of this is the entitlements that are associated with the DRI. They would not be able to then separately seek to rezone this property and transfer those entitlements to that property or sign it. They would have to get have a separate permission to do that, correct?
Judge, you are absolutely correct. That is a very salient question.
Maybe I should have been a land use attorney, but.
Let me ask you a question to follow up to Judge Norcutt. In order to take it out of the DRI, does the county have to agree to that?
The county does have some regulatory authority over that. The primary regulatory authority over it, Your Honor, is the Tampa Bay Regional Planning Council, which oversees DRIs. So
a government entity would have to agree to let it come out, correct?
that is correct, Your Honor.
Gotcha.
Judge, I think that what I would suggest to the court is that, like many of the cases that the court is seeing in both of the briefs, these are highly fact-specific determinations. I would respectfully suggest to the court that the 3 federal cases that the appellant is relying upon are very fact-specific cases that don't govern this court's analysis. And 2 of those cases, which the appellant really didn't talk about too much during the oral argument, Love Ladies and Palm Beach, had situations that the court felt were rather different from our situation here. And what I mean by that is that the regulatory scheme that was in place, that was being applied in those cases, which was Section 404 of the Clean Water Act, was a federal law that was not in place at the time these particular property owners acquired that property and developed their property, and was only later in place after they came in with their development applications. What I would suggest to the court is really more appropriate for the court to consider in framing the issues in this case are the litany of federal cases that the county cited, but I would point the court to 3 cases in particular. The first one is the United States Supreme Court's decision in Myrrh versus Wisconsin. That's a case which talks about the relevant parcel. It's a recent case from 2017. And the thing that's very important about that case, Your Honor, is that it talks about the court giving great weight to the way property is bounded and divided under state and local law. And so we're dealing with a DRI here, for better or for worse. Other states may not have a DRI process. Florida does. This developer has 1,000 acres that's been governed by a DRI for 40 years. Like it or not, he is subject to the regulations governing that DRI. The other 2 cases that I think are very important, actually 3 that I think are very important for the court that are Florida cases. One is the Ocean Palm case. And that's a case that's particularly important because it talks about how the property owner in that case treated the property. It talks about the fact that the property owner treated the property as a single economic unit. It talks about the fact that the property owner treated the property as a single economic unit under its development application. It is exactly the type of situation that we have here. The most significant case from a DRI perspective that we cited to the court that we think is right on point is Fox versus Treasure Coast. It's one of the few cases that's actually out there dealing with the DRI. In that particular situation, the court ruled that the property has to be looked at as a whole in considering whether or not a taking has occurred. In that particular circumstance, there was a DRI, it was over 1,000 acres, and roughly 20% or 338 acres, the Regional Planning Council that had governing authority over that particular property said could not be developed because it had wetlands. The third DCA looked at that situation and said that the relevant parcel in that case, just like our situation, was the entire DRI. And there was a takings claim that was filed in that case, and the court said that because the relevant parcel is the entire DRI, and because the property owner has been able to make reasonable economic use of the parcel as a whole, there was no taking. And keep in mind that that case, the restriction on the property was far greater than what we have here. The restriction on the property in that particular circumstance said that the property owner could not use 20% of the property. And the court said that doesn't constitute a taking. In our circumstance, if you do the math, we're talking about a piece of property that constitutes less than 1% of the overall land mass of this DRI. And the last case that I would refer the court to is a case that was dealing with a planned development, which Judge Northcutt, you talked about a little bit. I mean, DRIs are a type of planned unit development. So in broad general terms, that's what we're dealing with here. They're governed by a development order that is put in place that has review at both the state and regional level. And then that development order results in a zoning ordinance. That's why you see these companion ordinances floating through the case. You typically see the development order as 10-50, and you see the zoning ordinance as usually like PDR 96- whatever a number. And then it has usually a parenthesis and it has a number after that indicating the number of revisions. So they've had 10 plus revisions of this development order and this zoning ordinance over 40 years.
All right, you're right at the end of your time, but you haven't yet mentioned which third case you're wanting to emphasize. So
the last case I want to emphasize, Judge, is Polo versus Wellington. That was a case dealing with a 92-acre planned unit development, the same type of planned development that we're dealing with here that governs the Terra DRI. In that case, the court said the same thing. You have to look at the entire planned development for purposes of analyzing a takings claim.
Okay, thank you so much. Your time is up, so you wind up here, Mr. DeCon. Thank you. All right.
Your Honors, thank you very much for your time and attention this afternoon. We greatly appreciate it.
Thank you. Okay, Mr. Reese, you have Scotia over 4 minutes, if you're old enough to know what Scotia means.
It please the court. I want to circle back because Judge Jacobus hit on the very first 2 points I was going to raise here in rebuttal. The first is that if this wasn't a DRI, we wouldn't be sitting here today because there would be nothing for the court to point to include in the trial court to point to include in the total property calculus. Second, if Lake Lincoln wasn't a predecessor to the original developer, we wouldn't be sitting here today. So what the county and the trial court have done is crafted a very, very narrow rule that if property is included within a DRI, then all the DRI property can be included. But if and only if the property owner subject to the takings claim is also a predecessor of the original developer. There's not a case in the United States that supports that contention. And the county hasn't pointed to a decision that says that given the DRI regulatory framework, that should be dispositive. The second point that Judge Jacobus raised was the similarities between the Lost Tree case. And really all 3 federal circuit cases we cited in our brief are directly on point. The county's attorney says they're factually distinguishable. I just don't believe they are. All large acre developments, all constructed over a period of decades, all constructed in piecemeal fashion with various development plans and entitlements. The development proposals at issue were all physically, this is the court's language, physically and temporally remote from the development of other lands. We're on all 4 of those 3 authorities, particularly the Lost Tree decision. Compare the 2 cases, 1,000-acre mixed-use developments constructed over decades based on what the courts termed opportunistic progression. All the lands were independently permitted, developed, and sold off to third parties. And you've got a subject parcel left out there undeveloped that all use has been denied. The government entities in all 3 of those cases, Loveladies, Palm Beach Isles, and Lost Tree Village, all tried to increase the denominator to include basically lands that were purchased as part of the original transaction. And that was the losing side in all 3 of those cases. Like the court in Lost Tree, this court should decline the invitation to look at a 1,200-acre parent parcel simply because this owner's predecessor was a developer of the entire
Let me
community.
ask you, Mr. Reese, and I'm going to go study these cases closely, but in the cases you've just described, were the use applications, whatever they were they done separately, specifically to the parcels that were denied, or were they done as part of like an equivalent to what we have here in terms of amendment to a DRI order or DRI ordinance?
Yeah, and to answer the question, it wasn't necessarily segregating use, it was segregating types of property. In Loveladies, I think it was submerged lands. In Palm Beach Isles, it was wetlands, and in Lost Tree Village, it was wetlands. So it was that
I guess what I'm trying to get at is that here there was a request for modification to the whole, encompass the whole DRI ordinance and DRI order. Was that the situation in these cases you've described, or were they just focused on individual parcels?
I did some late research last night to see if any of those cases were DRIs, and to the best of my research, I couldn't find that they were. But here, but they were constructed in the same type of master plan development. It's clear. I mean, John's Community is a huge master plan
Honestly.
over in Vero Beach. Yeah. And the county makes much ado about our development application, but neglects to say that we're required to do that. We were required to go in and amend the Terra DRI ordinance and the zoning because that property falls within that regulatory scheme. It's not something we elected to do. It's the fact that we own property within that regulatory boundary. And so any application, I think Judge Northcutt, you asked this, any owner, whether it was Lake Lincoln or anybody else, would have still had to submit an application.
I get that. What is I find fascinating about these cases is you have overlapping principles that in opposition to each other that can arise from the very same set of facts.
It's true, but in this case, it's treating owners differently, correct? I mean, it's had this been any owner other than the predecessor to the original developer, we wouldn't be sitting here. because it would be evaluated on a standalone 10-acre parcel basis.
Right. Well, I've helped you use up all your rebuttal time. So time to say goodbye to you folks. And thank you very much. A very well argued, interesting case. It won't get me any points at a cocktail party, but you know, we nerds like this stuff.
Indeed.
Thank you very much to the panel, Your Honors.
Thank you. And you guys will, you leave our virtual courtroom by clicking the leave button, which is in red on your Zoom screen.